Good evening. This is John Milburn for Laws 11059 Statutory Interpretation. This is week 10. We're in the home run, or the home straight rather, and tonight we're dealing with a few issues. A couple of housekeeping issues to start with. So I take it by now all of you have made appropriate arrangements to sit the take-home paper. So you should know when it's to be released, when it's due. Be aware that extensions are very hard to come by, extremely hard to come by in terms of take-home papers outside my control, and don't attempt to do it after the event. So make every effort to be there and be ready for the take-home paper. The idea of the take-home paper is that it replaces the invigilated examination. So the alternative is for you to turn up at an exam centre at a time and sit without reference to the internet for 2 or maybe 3 hours and handwrite your answer. So this is the alternative to it, but the compromise is that we do expect you to sit the exam and be ready to go. Now, you won't need the entire time which is allocated for the take-home paper. You should be able to complete the task much quicker than that, much quicker. So if you've got other commitments, family, work, whatever it might be, health, don't be concerned. You've still got hopefully plenty of time to complete the task during the allocated period. From memory, I've given you 29 hours to complete the task. You can collaborate with each other, and therefore you can discuss the question with each other. But do be careful not to go too far in that regard. So ultimately the answers that you provide must be your own, and you cannot copy or replicate work of others. If you have any uncertainty about that, raise some questions in the Q&A and we'll try and set some further parameters. But I'm reminded, and thank you Jackie, that in the Laws 12062 unit ADR that I took last year, we had a session, or students organised a session at the release of the paper to discuss some of the content and speak in general terms about the approach that might be taken. We'll talk more about exam technique by reference to the examination from last year. We'll do that shortly. Now, but first, a quiz. What I'm going to ask you to do is be listening very carefully. If you're watching this as a recorded session, please participate, see how you go. Your task is to listen to a question, listen to 4 answers that I will provide you, A, B, C, and D, and in relation to each of the questions, and I'll do these one at a time, simply type the letter that you believe represents the best answer to the question. All right, so we know the rules of engagement, and I'll be watching to see who gets the answers correct the quickest. Here we go. Which statement is most correct? A. The standard law of precedent applies to statutory interpretation. B. Applying statutory interpretation rules is similar to applying the doctrine of precedent. C. The interpretation of a provision by a superior court is binding on courts below if the facts are sufficiently similar. And D. Precedent has no role to play in statutory interpretation. A, B, C, or D? We're getting the votes are coming in. Almost everyone went for C, which is what I think is the best answer. And Tanya first, Megan second, Rhonda third. Very close, very good. You'll have to keep track of your own scores here. 3, 2, 1, as it were. Question 2. Under which traditional common law approach would resort to extrinsic materials be least likely? A, the literal rule. B, the golden rule. C, the mischief rule. Or D, extrinsic materials were not used under any of those. We're getting the answers coming in. I think, I'm losing track here. The first answer, I think, was, my apologies. You all came in so fast it was hard to read. I think Amy, the answer I was looking for is A. So I think the first correct answer was Tim, followed by Gary. So the traditional common law approach, literal rule, is one where you wouldn't expect to resort to extrinsic materials. So Tim, you get 3 points. Gary, you get 2. Question number 3. And can parties appeal on the basis of errors in a court's statutory interpretation? A, yes. B, no. C, only if it was a single judge, not a full court. D, only if, without the error, there would have been a different outcome in the case. All right, so the answers we're getting are D, C, D, 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 C, and D. Lots of them. The best answer, I think, is A. Yes. Can parties appeal on the basis of errors in a court statutory interpretation? The answer is yes. That's a legitimate basis upon which someone could appeal. So you don't need to worry about whether there would have been a different outcome, which was the popular choice, and it doesn't have to be a single judge, not a full court. So the answer, I think, in broad terms is A, yes, was the one that I'd written down. So no points allocated that time. We're ready for our next quiz question, and this is the last one. The question's a little longer this time. Which of the common law rules is most likely being applied where a court decides to interpret, in the event a vessel sinks, all passengers are entitled to compensation, to exclude stowaways and pirates? So which of the common law rules is most likely applied where a court decides to interpret, in the event of a vessel sinks, all passengers are entitled to compensation, to exclude stowaways and pirates? Here we go. A, literal rule. B, golden rule. C, mischief rule. D, all of the above. Looking for the answers. A, literal. B, golden. C, mischief. D, all of the above. All right, thank you very much for your votes. I'm going to give that one to Megan, as the only answer, C, was the one that I was looking for, the mischief rules. So 3 points to Megan. Well done. And you may disagree with my answers. There's not necessarily a right answer with these, but of course, taking the role of judge, then you just have to accept my decision. So can I ask who won the contest? Did anyone get more than 3 points? Did anyone get more than 4 points? Did anyone get... All were winners, says right. All right, well, I'll do it this way. I'll count down. Sorry to take a while. So once you've got your number, when I call it, just type it in the machine. 10, 9, 8, 7, 6, 5. Someone must have got 5. You're not telling me. All right. 4. Megan got 5. Well done. Okay. So the topic for this week is statutory presumptions. And we are going to talk about that. We'll talk about the last year's examination as well. So when we talk about a statutory presumption, we're dealing with common law presumptions that judges might use in the interpretation of legislation. Just as an aside, those of you that might be using the excellent resource Interpretation Now, which is through the Australian Taxation Office. I applaud you. For those that are not, I urge you to consider it, commend it to you. Last week's episode, or last month's episode, dealt with issues to do with a brief summary of the top 10 statutory interpretations that you're likely to come across. So if you are a subscriber to that service, Interpretation Now, through the ATO, then you will have that resource available to you, and it's an excellent resource. I was speaking to the editors of that resource this week, and they're very enthusiastic and very knowledgeable. So it's a great general resource, not just for taxation issues, but generally statutory interpretation issues. Now, when we talk about common law presumptions, we understand and we know that Parliament can overrule those common law rules or common law presumptions and do so by legislation. In other words, when we're talking about a presumption, it is rebuttable. And it's rebuttable by Parliament by making contrary legislation. But when we talk about a presumption, we should also bear in mind that it is also rebuttable by the court itself, hearing a matter. So if there is a statutory interpretation presumption, then in certain circumstances, the court can rebut that presumption and not apply it. So it's not a statement of absolute principle, but more a starting point in terms of how you deal with the common law approach. Now, many of these are based on very powerful legal concepts. Some of these legal concepts aren't written down. For those of you that are doing Introduction to Law with me at the moment, we talked about some of these on Monday night. So some of the legal concepts are the rule of law, the sanctity of private property, the concept of freedom of the individual. In other words, even though they're not written down, these are powerful common law presumptions, and courts will only rebut those in circumstances where there is very good reason to do so, and generally it would have to be based on clear statements of intent and application in legislation. So these can be overruled. Common law approaches can be overruled, and bear in mind that it can be done through Parliament or by the courts or by both. So one of the presumptions that I'm sure you've heard about is the common law principle of self-incrimination and the right to remain silent. But that can be attacked and overturned by legislation. And certain bodies, investigative bodies, such as the Australian Crime Commission, the Crime and Corruption Commission, bodies of that nature do have statutory power to have people provide evidence, and in those circumstances, the principles around privilege against self-incrimination do not apply, but it's very clearly stated. So whenever you're interpreting something, you must consider the common law approaches, but then also consider how statute might have varied that. And indeed, statute might create presumptions, and we see that quite a lot. So if you look at the Acts Interpretation Act, you'll see a number of presumptions, but not just in that act. Can anyone think of a statutory presumption in the context of, say, criminal law? And there are a few. Well, one, for example, is that a child of tender years, let's say a 9-year-old, is presumed not to be capable of committing a criminal offence. Now, that's an irrebuttable presumption. There's another statutory presumption in relation to children that are a little older. I forget the age. I should know it straight away, but it might be 12 or 13, or 14 even, where there's a presumption that the child, it's a rebuttable presumption that the child is not able to commit a crime. There's also the mens rea, says Tim. Right to a jury, says Tammy. In certain circumstances, there are many criminal matters that are prosecuted without a jury. So the point is that these statutory presumptions can appear in all sorts of different statutes, not just the Acts Interpretation Act. So when you're looking at these statutory presumptions, you need to consider the legislative provisions, but always do so within context and always do so in light of purpose. Now, that reminds me, just as a refresher, if I talk about legislation being considered from a purposive approach, what's the case that comes to your mind most readily? Dealing with the purposive approach? Any takers? Project Blue Sky. Very good. And I agree, that's the one that comes to my mind. What case comes to your mind if we talk about legislation being considered within context other than Project Blue Sky? Rhonda's got it. CIC and Bankstown. They're the two that I think of within those parameters. Okay, we ready for another quiz or two? It's quiz night tonight. This one is just A or B. Keep your progressive scores because Megan hasn't got there yet. A statutory presumption is rebutted by A, clear words, or B, clear implication, such as where otherwise the provision would be meaningless. We're getting a mixture? It's a trick question because it can be either. Sorry about that. So that's a false start. A and B, Tim got it, and Rhonda said, I knew that. So an example is Coco against the Crown, and that's 179 CLR 127. It's a 1994 decision, and the plurality said the presumption is rebuttable and will be displaced if there's a clear implication that authority to enter or remain on premises was intended. So it can be either one. Now, here's a real quiz. So we're ready for this one? A, B, C, or D. If an expression which has a long-standing meaning at common law is included in Commonwealth legislation, A, the court will always apply the established definition of it. B, the courts will presume the common law meaning applies unless the context suggests otherwise. C, the courts will never use a common law definition, only a statutory or dictionary definition. And D, the courts would not apply any presumption in this situation. We're getting some votes. Very good. B. So we'll give that one Rhonda 3, Gary 2, Megan 1. Apologies to Amy, Tammy, Nigel and others, but you got it right. Next one, A, B, C or D. Which of the following is incorrect? A, there is a presumption that Parliament does not intend to interfere with vested property rights. B, native title is presumed not to have been exhausted by legislation except by clear and plain intent. C, it is presumed that all crimes must have some form of mens rea. And D, they are all correct. Very good answers. My view is it's D. So I'm going to give that to Rhonda 3, Tim 2, Nigel 1. Amy, you came fourth again. Just missing out. Jackie just missed out again as well. And Tanya. We're on to the next one. Make sure you keep your scores. Does legislation have extraterritorial effect? A, yes. B, no. C, not usually. D, Commonwealth legislation can. State and territory legislation cannot. Okay. So the answer I believe is best is C. So I'll give Nigel 3 points, Gareth 2, Megan 1. Jackie, you just missed out again. Just missed out again. All right, so well done. In which of the following would it not be presumed that legislation binds the Crown? A, all Commonwealth legislation. B, criminal legislation. C, legislation in South Australia. D, none. The presumption always applies unless it is rebutted. I think we've got all the answers. I think everyone, Tim gives up. I think everyone said D, but I'm going with C, South Australia. Hang in there, we've got a few more yet. Where legislation provides for women who give birth to have 3 months paid maternity leave, and it is unclear whether that applies where a child is stillborn, A, the court will presume the legislation applies to live births only. B, the court will apply it to all births, lives or stillborn, because legislation refers more to labour than motherhood. C, the court will favour a broad construction in favour of the mother if that was appropriate considering the context and purpose. And D, the court will refer the matter to parliamentary for clarification. And we're getting lots of answers for correct C. Tim 3, Nigel 2, Megan 1. Apologies to Gary, Jackie, Tanya, who just missed out. Last one. Which of the following statutory presumptions has been recognised as a fundamental right? A, presumption against retrospective criminal laws. B, presumption that legislation does not bind the Crown. C, presumption against extraterritorial effect. And D, presumption that legislation does not take away jurisdiction from courts. Thank you for your votes. I'm going to give this one to 3 to Tanya, 2 to Jackie, and 1 to Megan. Okay, so is anyone 15 points, 14, 13, 12, 11, 10, 9, somebody's got to be 9, 8, Tim 8, well done Tim. Okay, very good. Now, the examination that we set last year was pretty tough, but people had limited time to do it. So I take it everyone has looked at last year's exam, and I think I provided you with the answer guide. Is that correct? All right. So if you've got those documents there, I'll invite you to call them up onto your screen, because what I want to do is go through the question and look at the answer guide, and then invite you to tell me how we might have come to that conclusion. So if you've got, and this is in Moodle under the assessments area, if you're watching this as a recorded session, it was a thing called a ProctorU online paper, which was experimental. The university was kind enough to invite me to be the one to experiment in this regard, and it was essentially an online examination in invigilated form, and this is the question the students had to answer. So let's share the screen, and we'll look at the question, and you can tell me something about the answers. Now, you've got my guide, so I'd ask you not to slavishly just follow that, but to consider the material from your own context. So on the screen now you should see the assessment tasks for last year's examination. And what we're doing now serves as my guide, if you like, to this year's examination. So the first question, Maxwell and Murphy, was 400 words, excluding footnote referencing, and you had to analyse pages 96 to 98 of your text, that is the second edition, and had to consider whether that case was in accordance with the decision of Jaeger against the Crown, which was the previous case example on page 95. So, can I ask this, did anyone consider my answer and believe that it was incorrect or perhaps deficient, or that there may have simply been a different, perhaps better way of approaching this question of analysing Maxwell and Murphy? Any comments? Stop the share there for a moment. Any takers? All right. So Maxwell and Murphy dealt with the issue of potential retrospective liabilities. And if you've got my answer guide there, you'll be able to read that for yourself. You'll see the relevance to tonight's session is that I mentioned the presumption that would apply, and that is that legislation does not operate retrospectively as one of the common law presumptions. And the go-to case in this regard, I think, is Coco against the Crown, because that's important for this general proposition that unless the presumption is excluded expressly or by express implication, then it will apply. So that is common law presumptions considered by the court. In Jaeger against the Crown, the courts considered the purpose of the Act in the context of what Parliament had intended. And you'll see in the answer guide that I said the question relates to the intent of Parliament, or both questions relate to the intent of Parliament, and they both provide examples as to how courts consider the issue of intent. So when Parliament created the law, there's the objective process to consider, and again, there's reference in there to Project Blue Sky. So always a good idea to incorporate that case somewhere in an answer in essay form in relation to statutory interpretation. Now, I don't know how many words it is were in my study, in my answer guide. It's not meant to be a model answer. It was only 250 words, so you could have gone well beyond what I'd written there. Any questions? Any thoughts? Or all fine? Nobody disagrees with that? Okay. Let's go and have a look at the more difficult exercise, the one that counted for 50 marks, which was, of course, the bulk of the assessment, and half the assessment for the entire unit. So we'll share the screen once again, and you'll see the hypothetical facts. Very common for me to write a question where I ask you to assume that you're either a lawyer working in private practice. I'm sorry, I've given you the answer guide. I'll go try and give you the question. So I'll stop the share, go back to the question, my apologies. So hopefully now you're looking at the question number 2. And it's very common for me to write a question where I assume that ask you to assume that you're a lawyer working in private practice, or that you're perhaps a legal advisor in a community legal centre, or you're a lawyer working in a government organisation, or you're somehow associated with the drafting process for legislation or otherwise. In other words, to put some practical aspect to this. If I ask you to assume that that is the case, then I'd ask you to write the answer in that mode. So don't write it as an essay, but write it as you're providing a genuine response to whoever is asking you. So in this case, your supervising partner is asking you to answer questions about the Work Health and Safety Act, and therefore I want you to answer the question as if you are that lawyer and as if you are writing to the partner in your firm. Now, that's important in a couple of ways because it means that you need to be flexible in the way in which you present your material so that it's not just straight essay form. You're flexible in different approaches to writing. And secondly, it's important that you consider who's the recipient of the communication. So if I'd asked you to answer this question by writing to the client, then it's in all likelihood, you would have provided something that has a different focus and possibly different content than if you're writing to a partner in the law firm. Can anyone think of any obvious reasons why there would be a difference in style and content when writing to a partner in a law firm as opposed to writing to, say, a client in relation to the same factual circumstance? Amy says it's a different audience. Gareth says understanding. Megan, the different nature of the audience and technical issues. I agree with all of those things.
Probably more plain English for a client too.
Yes, more plain English, less technical terms. Tim says it's a mixture of Iraq, 5-step process in the assessment. So, yeah, so if you're writing to your managing partner, you wouldn't say, you know, something like the Acts Interpretation Act 1959, which is an act of Parliament through Queensland, and Queensland is unicameral. There is no Senate. You know, the partner is just going to groan if they see that sort of nonsense. Whereas if I ask you to write an essay question in relation to generally how Parliament in Queensland might go about creating something like the Acts Interpretation Act in an essay format, then you might go into that sort of thing. So that's where you need to consider the question carefully and look at the focus. There's a good question here, some discussion on the chat facility about the IRAC method, IRAC, which for those of you that are studying or have studied Introduction to Law, you'll know that is the acronym which talks about legal reasoning, where we look at a question and we consider in order, what are the legal issues, which is the I, what are the legal rules, which is the R, how do we apply the rules to the issues, which is the A, and C relates to the conclusion. Now, I have a bit of an aversion to students slavishly following the IRAC methodology in answering questions, in that I guess I shouldn't I shouldn't do this, but I kind of internally groan if I see paragraph 1 is headed issues. If paragraph 2 is rules and 3 application and conclusion. There's nothing wrong with the legal logic. So AJ's been drumming it in. AJ and I, Amanda, we did have some joint sessions on this in Introduction to Law. It's a perfectly legitimate and expected form of legal logic, but you've just got to be careful about being a prisoner to it. So go through that legal logic, but don't necessarily think that you've got to put everything in a legal assessment with those specific headings, because it will trap you. It just makes it too difficult. Go through the thought process. So be mindful of the situation and request. Yep. Any questions? Is that different to what AJ and others were telling you? And you will get differences between different unit coordinators. Okay, so Tim says, I think he gets what I'm saying. All right, so go through the legal logic. It's perfectly legitimate legal reasoning. Use the headings if you like, but with me, do it guardedly. Maybe just change the wording a little to camouflage it just that bit. But it's perfect, it's the right way to go. There are other acronyms. So, for example, you can add a C at the start so that you go conclusion, issues, rule, application, conclusion. And the reason I say that is that when you're preparing a submission, oral or in writing, you're presenting something to a court, it often is very useful to start with your conclusion, to state your conclusion. You'll then get a very immediate response from the judge as to whether they believe that you've got a chance, and then you've just got to paddle really hard to get there. Does that make sense? So sometimes doing that is a good way to go. Another variation is the MIRAC, where you state the material facts, and then you go into the issues, the rules, the application, and the conclusion. So that's perfectly legitimate in different circumstances. And I think it's a very good way of doing things because it shows that you've got an understanding of the key facts. From that, you can draw the issues, then talk about the rules and the application. So MIRAC might be an option. These are just different varieties. Gary, did you have a question? All right. So let's go back.
I do have a question if you don't mind, John.
Yes, Amy. Yep,
so
please.
essentially, if we are doing, if it's similar to last year's and we're doing a memorandum of advice to a lawyer, we would use obviously all of our legal reasoning skills, but do it in IRAC form, but without headings, like make it more of a flowing format.
Yes, that's very good. Or use different type of headings. There's nothing at all wrong with having headings. I like it, but it's just if you try to use those exact words, then you may find yourself in a situation of saying, I don't know how to fill this peg. With this particular question, it just doesn't flow. So a good example is the question that was set last year, where I ask you the specific questions, and there were 17 of them. If you're slavishly, and this is not meant to be a criticism using the IRAC method at all, but if you're trying to use the IRAC method in every single question, you're going to create yourself stress. So for example, I'm jumping ahead, but question 7 in the problem that I set last year, in terms of the application phase, was, question number 9 was, who will prosecute? Now, given the word count and the time available to you, it may be that your answer will be something like, the Director of Public Prosecutions refer to section such and such of the Act and or the Director's guidelines. Now, how are you going to answer question 9 if you want to put issues, rules, applications, conclusion without it looking forced, is really what I'm trying to say.
I understand what you're saying, because I actually looked at all of this and I couldn't see actually a way of applying IRAC to this at all.
Right. No, and that's fine. It's always there. You're always thinking about it. It's a legitimate form of legal reasoning. But in terms of answering this question, I just don't think it would work. Or if you tried it, it would make it very hard.
I was looking more at the fact that you already had the headings there for us, and I was looking at writing it in exactly that way, that, I'd start off with the identification phase, the operative phase, and actually treat each one of those headings within its own right. That's how I approached it.
Exactly. And that was my intention in writing the question in that format, to say, look, when it comes to statutory interpretation, the logic is a little different. So we're still thinking in general terms, what are the issues? What are the rules? How do I apply them? But when we're dealing with straightforward statutory interpretation, the headings are more like identification phase, number 1, operative provisions, number 2, exploration phase, number 3, application phase, number 4. Ultimately, you might have number 5 is a conclusion. So there's some similarity there with IRAC, but I'm using different words, different headings, and it invokes a slightly different thought process. I hope that makes sense. So Jackie says, yep, so what I'm trying to do is ask you to be flexible, adaptable, use an approach that I think is appropriate, without necessarily sticking to just it. And Tim's right. What you'll notice is the similarity between the headings that I included in that question with the flowchart process that you would have adopted in your assessment, or even the flowchart that you'll see at the back of your textbook, which is very similar, if you like, the headings that I've put in the question. Because in the flowchart, Michelle Sanson says, The first part is identification phase, the second is exploration phase, and the third is application phase. So in your own flowcharts, in your own assessment work for assessment number 2, and I do apologise for not having got those results back to you yet, I'll come back to that shortly. The idea is that you have a flowchart process that works for you. So having created the flowchart, having created this toolkit about how to approach a statutory interpretation problem, as much as possible, I'd like you to use that as the answer for your question in the take-home paper. Hope that makes sense without confusing you too much. Okay. Right, let's go back to the question. And this was the online paper from last year. So you're you have to give advice to your partner in the law firm, and you're dealing with the situation of the death where there are certain factors that may have had statutory interpretation relevance. So number 1 deals with the identification phrase and specifically jurisdiction. Does the Act apply in the current factual circumstances? Support your answer. What do I mean by jurisdiction generally? What comes to mind when I say use that word? Jurisdiction? What does it mean?
The area that you're in and the court that you're approaching. Yes,
it can be the geographical location. It can be the court that you approach. It can be the area of relevance, says Amy. Whether or not the law is state or commonwealth, says Gary. So all of those things are relevant. I suppose you could answer it in this way by asking yourself, does the court that I'm approaching have the lawful ability to deal with these facts and provide the remedy that I seek? So if it may be that in some cases you have to consider very carefully the jurisdiction of the court or the tribunal to determine whether or not the Act will apply in the circumstances before that tribunal. So number 1 is always, does the Act apply in the current factual circumstances? Because if the Act doesn't apply, then that's really the end of it, isn't it? There's nothing to interpret. The Act doesn't apply in the circumstances. So in the answer guide, if you've got it there, I said that the question requires you to provide an explanation, to apply self-regulation, and to apply critical evaluation, which is another area of where you need to look very carefully, and that is the first word of a question gives you an idea of the type of response required. So number 1, you've got to tailor it to the recipient. This is a partner in the law firm. And when the partner in the law firm says, I want you to explain something, what you're really doing is demonstrating your ability to communicate results. That is the ability to effectively and persuasively communicate the results of your critical thinking. That's the explanation. If I ask you to critically evaluate, then the questioner asks you to consider arguments weighing up for and against something. If I ask you to analyse something, then it's your ability to do those sorts of things, but emphasise the hidden features, consider those and investigate them and discuss them. So having a look at the first word is often very important in that regard. Okay, so the key provisions in this particular case were contained in Part 2A, which deal with industrial manslaughter, sections 34A to 34D. Now, the second question in the answer last year, or question last year, identify the division that contains 34C and 34D. When did it commence? So finding the division is pretty easy, but finding the date of commencement, how would you find that? And you can refer to your own toolkit in that regard.
I have to admit, in this instance, I actually took way too much for a general assumption and I didn't look into it further until I actually sat back and had another go. It was actually, for me, it was a bit of a trip.
Right, okay. So you worked your way through it carefully, Tammy?
When I went back, yeah, I did. But to start off with, I thought, oh, this is easy. That's easy. That was a trick question. Of course it's commenced. But then I'm like, well, hang on a minute. When did it commence? That's the question.
Excellent. Great. And we're not really talking, we're not giving answers tonight, but what we're really doing is, if you haven't been through this exercise, I urge you to do so. So thank you, Tammy, for doing that. Because, yeah, it can be a little trickier than you think. So I do ask you to use your statutory interpretation toolkit. I do ask you always to consider the purposive approach. And remember, of course, when you're talking about the purposive approach in Queensland legislation, not only should you think about Project Blue Sky, but you should also think about Section 14A, that's capital A, of the Acts Interpretation Act 1954, because that specifically states that when you interpret a provision of an Act, a Queensland Act, the interpretation that will best achieve the purpose of the Act is to be preferred to any other interpretation. So that's almost got to be in every answer that you write if you're talking about the purpose of Queensland-based legislation. And you'll see that I've also said that you should consider the long title, the objects clause, the definitions clause, which is section 4, and also schedule 5, other important terms and the application. So in force means that you consider when the Act is in force, and unless otherwise stated, legislation remains in force until it gains assent. So have a look at section 15 of the Acts Interpretation Act, but you've probably already worked that out. And that should be part of your toolkit, I imagine. So that part that we were talking about in the question from last year was introduced by way of amendment in 2017. So you do need to look at specific amending acts, and you need to know how to find these amendment acts, and you'll need to work backwards. So you've got the advantage here of knowing what I think are the key aspects of the answer. But if you don't know how to find these things, and I've purposely not included too many links, then you've got to go through that exercise and find it. So, and I've also given you some idea of where you can look. For example, the Queensland Parliamentary website provides for the date of the Amendment Act, and you'll see that it was 23 October 2017. You'll see also the point in time material, and that should be on your screen now. The point in time versions. So you've got to identify the relevant date of the particular matter and then be able to call up the relevant version of the Act at that time. Queensland Legislation Handbook will help you in that regard, and that's all through the Office of the Queensland Parliamentary Council. So the Queensland Parliamentary Procedures Handbook would be useful in that regard as well. All right, so I'll leave you to work through that. Were there any, now a couple of things have come up. Oh, so Jackie says, the Fair Work Commission, a number of objections can be raised, such as employers stating employees not protected from unfair dismissal if they don't meet the minimum employment period. Therefore, there would be no jurisdiction to make a determination. Yes, so even within those areas of, but for those commissions, tribunals and courts where you think there would be jurisdiction, legislation may deprive you of what you would think would be the jurisdiction to hear a matter. Tim says, possibly couldn't see the use of a toolkit 10 weeks ago, but now it's starting to, the penny's starting to drop. And it's not just for statutory interpretation that I want you to use this toolkit. If you're dealing with a contract matter, torts matter, whatever it is, Always remember that statutory interpretation is going to be relevant for your discussions. So don't think of this as just for this unit and forget it. The toolkit stays with you, and I urge you to expand upon it and use it as your practical go-to method of statutory interpretation. All right, so if you haven't been through the exercise of looking at last year's examination and studying carefully the answer guide, I urge you to do that now, and it will be a great help to you in answering this year's question. Remember, of course, that when you're doing so, you need to consider not only the legislation, but also the common law, and you need to consider the subordinate legislation. You need to consider regulations very often in the context of these answers. You need to consider the relevant time and be able to identify when legislation came into effect and look at the point in time material relevant to that question. All right, so that might do us for this evening. You've been very patient. Who was our winner? It was Tim, wasn't it? So congratulations, Tim. Must have just pipped Megan in the last answer. All right, so any questions before we wrap up for this evening? All good? All right, thank you very much. We'll see you next week. And just as a final note, I do apologise for not having the responses to you for the second assessment. I've just been tied up with some work with a colleague in terms of some other work. It has put me behind a little, but it will be, I will get that to you as soon as I can. So thank you very much for your patience. All right, all the best, and we'll see you next week. Bye for now.